And essentially, the court in doing that found that the state adequately charged proximate cause within the indictment. So now what we have to show is that we have provided enough evidence for the case to get to a jury for proximate cause, which is essentially their argument that we haven't. In Johnson versus State, which was an involuntary manslaughter charge, and cruelty to children in the second, that was before the new statute for murder in the second degree came about. In that case, a mother left a 3-year-old, a 4-year-old, and a 2-year-old completely unattended for an extended period of time in a room that had a space heater. And in that case, the evidence was sufficient to find that she committed involuntary manslaughter and the commission of reckless conduct. Obviously, owning a space heater is in itself illegal, but the manner in which she owned it was illegal, and that is what the state's contention is. Owning a firearm and owning ammunition is not in itself illegal. Owning it and allowing access to it in the manner that the defendant did rises to the level of reckless conduct, it rises to the level of criminal negligence, and therefore it rises to the level of a criminal act. For proximate cause, for both criminal negligence under Putnam versus State, 257 Georgia Appellate Court 902, and proximate cause under Butler versus State, 363 Georgia Appellate Court 753. These are questions for the jury to determine. The jury is to determine whether or not the state has proven criminal negligence and whether or not the state has proven proximate cause, as long as we've provided some evidence that the defendant was criminally negligent and that these deaths were the proximate cause of his criminal negligence. And the state certainly has provided a lot of evidence of warnings that the defendant received in the form of Colt's deteriorating mental health, in the form of the violence that he was showing at home and alluding to in his text messages, as well as the red flags that were clearly present that showed that Colt was obsessed with school shooters. So there's definitely sufficient warnings. Those warnings are what make the manner in which Colt harmed people reasonably foreseeable. I don't believe the standard is that the state has to prove that the death in the exact manner in which Colt committed this crime is reasonably foreseeable, that he took a gun on a bus to the school. But it is reasonably foreseeable that Colt would kill people with his gun and harm people with his gun, and that's certainly when you provide a 14-year-old with mental health issues, with violent tendencies, and a clear interest in school shooters, it is reasonably foreseeable that he will use that gun to shoot people. And the state has provided enough evidence for that to go to a jury.
All right. I do think that proximate cause is almost always a question of fact for the jury to determine. I do think that there is evidence upon which the jury could in fact find proximate cause here, so I will deny the directed verdict.
And Your Honor, before we move on to charge conference, may I be excused to go continue to prepare for closings?
Yes.
Thank you.
All right. So coming back to the Lesters. All right. So I've lost the email now. I was going to say, so the defense wants.
We can start with the ones we don't object to.
Okay.
I don't know that they'll simplify much, but on counts 5 and 7, involuntary manslaughter is indicted as an unlawful act. They are asking for involuntary manslaughter as a lawful act, and of course, in an unlawful manner. that as a lesser included on those 2 counts.
Okay.
That's it.
All right, so if I understand the email correctly, then we have, they're requesting 3 lessers for murder of the 2nd degree, involuntary manslaughter, lawful act, involuntary manslaughter, unlawful act, and contributing to the delinquency of a minor.
Yes. We do object to those, starting with involuntary manslaughter as a lawful act. I think essentially to get that as a lesser included, the state would have had to, there has to be some evidence that merits the lesser included, being that either the victims in those counts, count 1 and 3, were over 18, or that there wasn't quote excessive pain. I don't know that any evidence has been put forth showing that. I do have a case, it's Castro Moran versus State, and that's 356 Georgia Appeals 248. That's a 2020 case.
Did you say 248 or 348?
248.
Okay.
And essentially that case says, a trial court is justified in refusing to charge on a lesser offense where there's no evidence that the defendant committed a lesser offense. I think there was a question of, for example, the victim's age, that could be appropriate, but I don't know under this situation that it is appropriate.
Mr. Hobbs? Is it Hobbs or Mr. Barrett?
Mr. Barry. Okay. Mr. Hobbs.
Miscue.
Judge, so on the involuntary manslaughter, state must prove the defendant caused the death of another person without intending to by committing the offense of reckless conduct, which is charged on other defendants, though in counts 1 and 2, obviously it's charged as a cruelty in the second. We believe, and this will kind of dovetail into the involuntary manslaughter lawful act, because the only difference between the 2 is an allegation of reckless conduct versus committing a lawful act in an unlawful manner, which was likely to cause death or serious bodily injury. We feel it is appropriate due to the fact that he is charged in such a way that he's absent all malice, so without intending to, which is the second element of involuntary manslaughter, causing the death of another person by committing the offense of reckless conduct. So reckless conduct is defined as endangering bodily safety by consciously disregarding substantial and unjustifiable risk that the defendant's act, in this case, leaving access to a firearm and ammunition under circumstances the state intends to prove. In terms of consciously disregarding that risk would endanger the safety of another person. Obviously, the conscious disregard must rise to the level of a gross deviation. We think the jury could find that he committed involuntary manslaughter based on the elements of that as applied to counts, what is it, 1 and 3 for the minors involved. Yes, sir. Same thing for the involuntary on the lawful act. If they determine, they being the jury, that the way in which he stored the weapon and ammunition did not rise to the level of reckless conduct, then they could find that he committed a lawful act in how he stored the weapons, because it's not against the law in Georgia to store weapons in any particular way or any requirement that the weapons be locked up. And the jury then determined that the way he stored them, although lawful, still was likely to cause death or serious bodily injury. They could find the involuntary manslaughter lawful act in an unlawful manner, so we would ask the court to include both of those as lessers to counts 1 and 3.
Or, do I understand Ms. Daniels' argument that you're saying because of the additional elements of the age of the victims that these lessers don't apply? Is that?
I am not saying that involuntary, so I was only talking specifically about unlawful act. I am not saying that there is not a world where involuntary manslaughter, unlawful act could be a lesser included, but I think the evidence that that lesser included should be given under this Castro-Moran's case is there's no evidence that is kind of hard to prove a negative. Like I said, we're talking about the elements of age and causing cruel and excessive pain. There's nothing to show that those elements are in question. There's been no evidence presented that those elements are in question. And when the differing elements between the lesser included and the indicted charge, if that's not present, there's no reason, the trial court's not compelled to give that lesser included.
Do you have any case that goes through sort of a factual analysis? I mean, I realize that the general rule, there has to be some evidence to give a charge, but do you have a case that we can use as an analogy, or?
Not for these specific charges. Let me make sure that I have the right case here. The Castro-Moran case, essentially, so it's not exactly the same, of course, but that was essentially failure to seek medical care situation, cruelty to children in the second, resulting in murder in the second. And so in that case, so it is, I think it tracks the logic, the case that I provided.
Mr. House, was there a specific case that you all felt was helpful?
No, Judge, we would just point to the language that the court has already articulated, and that if there's any evidence, the court should give the lesser included offense. And we think there is in this case.
All right. Reserve on that one, but look at some cases on the recess here. Are you also requesting, according to the email, contributing to the delinquency of a minor for the murder in the second?
Yes, sir, we are.
Any argument, or did you want to?
Sure, I can go first. So that's obviously a very extensive statute with many different provisions to it, and refers back to a different statute in terms of the definitions. However, what that statute says, based on 1612.1, subsection B, subsection 3, is that a person commits the offense of contributing to the delinquency of a minor, the minor in this case being Colt Gray, when such person willfully commits an act, or more importantly, as it says in the statute, willfully fails to act, when such an omission would cause a minor, Colt Gray, to be adjudicated to be a dependent child, as such term is defined in Code Section 1511-2. 1511-2, dependent child is defined as a child who has been neglected and is in need of protection by the court. Neglect is defined in 1511-2, subsection 48, subsection A, as the failure to provide proper parental care or control, subsistence, education, or required by law, or other care or control necessary for a child's physical, mental, or emotional health or morals. A child, as it says in the same statute, is considered in need of the protection of the court if that child commits what's known as a designated felony, either A or B. The charges against Colt Gray in his indictment qualify as a designated felony under A, and because the way this case is indicted charges Colin Gray, irrespective of intent, with failing to lock up his gun, failing to supervise Colt, failing to provide him with mental health care, that fits the statute. It's clear that he has been charged with what would be the equivalent of designated felonies, and as such under that statute would be defined as a dependent child who's been neglected by Colin Gray's failure to do certain things. This statute fits, and as the court stated, there is evidence, there's only slight evidence necessary in order to give the charge, and in this case, frankly, Judge, this charge fits better with what the evidence that So we would ask the court to charge with contributing to the delinquency of a minor.
And Judge, I'll address that, and then I do need to circle back to address involuntary manslaughter, lawful act in relation to the cruelty or the murder second charges. But regarding the contributing to the delinquency of a minor, I do have one case. It's Stave, S-T-A-I-V versus State. That's 309 Georgia Appeals 785. That's a 2011 case, and I believe the statutes that is looking at were slightly different at the time. So it's looking at cruelty in the second and then contributing to the deprivation of a minor, but the logic is still the same. That case says that they do not merge as a matter of law. And I think, like I said, even though the statute language might be slightly different, the policy behind the statutes and the wording of them track along with what our statutes are now. The other thing, Judge, and the main issue that we would take with the contributing to the delinquency of a minor, well, we wouldn't disagree with Mr. Hobbs that it could very easily be argued that the defendant contributed to the delinquency of Colt Gray. Adding this as a lesser included is putting a lesser included with an entirely different victim. The named victims in these counts are Christian and Mason, and as well as all the mentally and physically injured victims in the indictments. To include a lesser included where the state has to prove a different victim, which in contributing to delinquency of minor, that would necessarily, under that statute, have to be Colt Gray. That doesn't logically track with how a lesser included works. I can't think of any scenario where you could put in a lesser included that would require the state to prove an entirely separate victim just because that victim is part of the language of the charging statute in the indicted charge.
Last words?
Sure, Judge. We would just rest on the argument as previously given in that if there is any evidence, the court should charge it, and we believe there is sufficient evidence in this case to warrant charging contributing to the delinquency of a minor based on the evidence that's been presented thus far.
And Judge, can I go back to the lawful act, unlawful manner for murder in the second?
Okay.
So our argument here is different than that for felony involuntary manslaughter, in that, like I said earlier, we conceded that under current case law, involuntary manslaughter lawful act would be an appropriate lesser included for counts 5 and 7. Because the wording is different for involuntary manslaughter and murder in the second, it doesn't line up to be a lesser included because the mens rea for those two counts, for those two charges, is the same. In involuntary manslaughter lawful act, the pattern charges, so that's criminal pattern charge 2.10.44, specifically says under the bench notes, you must include in your instruction the definition of criminal negligence, which is the same mens rea for the predicate cruelty to children in the second to get to murder in the second. Inherently, if a jury were to find that the state proved criminal negligence as they would be instructed under the pattern by the court, then they have found that predicate mens rea to find cruelty in the second and thereby logically find murder in the second. It's a different language, a different mens rea than laid out in felony involuntary manslaughter. I don't have the case citation in front of me, but that would be contrasted with State versus MacGyver, which very wordily and lengthily lays out the logic of why lawful act would be a lesser included of unlawful act in involuntary manslaughter. But because the mens rea specifically in murder in the second is criminal negligence, and because the mens rea for a lawful act in an unlawful manner is specifically criminal negligence, to instruct the jury that they could find it to be a lawful act when if you reach that predicate mens rea, you've inherently committed cruelty to children in the second, would be cognitively dissonant and not an accurate statement of the law.
Anything else on that?
Sure, Judge. So the way this case has been changed is unique to the jurisprudence in this state in regards to Colin Gray is charged with cruelty to the second in not to anyone he ever came in contact with. We've got a couple of different layers in terms of how he's charged with cruelty to the second, in terms of he's charged with cruelty to the second based on what someone else, an intervening act, did to these other folks. So what we think is that the way the statute is with lawful, you could still find criminal negligence, yet not find the proximate cause in cause and fact and legal cause necessary to go that further step to the cruelty in the second. Therefore, we think that the evidence that's presented could be criminal negligence under both situations, murder in the second, and also involuntary based on a lawful act, because there is no law that he lock up his guns. And find in both cases that he was negligent, yet not find the proximate cause necessary for the murder in the second, and then they would be authorized to find involuntary based on a lawful act. So based on there being slight evidence or some evidence that would satisfy that, we would ask the court to charge involuntary based on a lawful act.
Judge, may I just briefly respond to that?
Go ahead.
Our position would be if the jury were to find that Colin Gray committed criminal negligence, and then there's no proximate cause, and then something horrible happens over here, and the jury does not find that there's a proximate causation between the two, that's just not a crime. So that would be the jury's prerogative as the finder of fact.
You're saying it still wouldn't be involuntary?
It still wouldn't be involuntary manslaughter. It'd be two things that, without proximate cause, are not legally related.
All right.
And I'm sure they'll argue that extensively.
All right, let's see, argument, so we have cruelty to children, various counts through the indictment. You're arguing or asking for contributing to delinquency. Any additional argument?
No, sir, it would be the same one I've already articulated.
Any additional? And we have, let's see, count 6 to 8, 27 through 29, reckless conduct. It says not asking for a lesser included.
We're not asking for a lesser on that, Judge.
Okay.
And they are still asking for furnishing a firearm.
Consult with my boss.
So you're at, but you are asking for furnishing a firearm to a minor?
We'll be asked for the furnishing. We'll be asked for the furnishing pistol. Yes, Judge, we're gonna ask for, it's on my phone. Furnishing a pistol, it's actually furnishing a pistol or revolver to a minor. So I will go ahead and admit to the fact that that statute does not perfectly track what we have in this case, and obviously the allegation is not that he used a pistol or a firearm. However, the language in 1611-101.1 does use the same language as the cruelty counts as presented in the indictment. The spirit of that law in that providing a firearm to a minor who then does something illegal with it would fit the facts that we have in this case, therefore being slight evidence that it is enough to get the charge to go to the jury, so we would ask the court to charge that.
Standing.
And Judge, that just, I think that charge just wouldn't follow the evidence in this case at all. So that statute says, for the purposes of this code section, pistol or revolver means a handgun as defined in code section 1611-125.1. Again, the court's not required to give a charge if there's no evidence for that. There's been no evidence in this case that Colin Gray furnished a handgun to Colt Gray.
They concede that. They're basically saying, we want to transfer it to a long gun, a firearm.
Well, that's just not what the law says. I can make my own personal policy statements about whether or not I think that should be illegal, but that's just not what the law says. And the law does not say that it's illegal to furnish this kind of firearm
So,
to
jury it's illegal to give them a handgun, but not illegal to give them a hunting rifle.
I believe the way that statute is written, it says pistol or revolver, meaning a handgun. However, we believe that the intent of that statute is to prevent an adult from furnishing a weapon, a firearm, to a minor. That's what our argument is. There really should be no difference between an AR-style rifle versus a handgun or a pistol. We think the intent of the legislature in passing that is to prevent the same exact act. Therefore, we would ask the court to charge it.
And Judge, they wrote in specific parameters for that, and then under 1611 125.1, handgun is additionally defined. That's, I don't know if the law was written to the exact intent to contemplate every scenario, but the law is very, very clear.
All right. I'll have to look at some case law and the lessons there, so let's go through the charge packet.
Okay. Ready, Judge?
Does everyone's packet have 13 pages? I just want to make sure we're all looking at the same thing.
Yes, sir.
Yes, sir.
So I know Ms. Daniel's familiar with this, but Mr. Hodge, what we'll do is I'll just go page by page. This is a preliminary charge packet. For instance, if there's no issue on page 1, I'll put a check on page 1. This will be a court's exhibit so that they can compare what we said we were, what changes we were making based on this preliminary packet.
Yes, sir.
Okay. So page 1, the only thing that wouldn't be straight from the pattern is the state just asked, I guess, that this guy summarize the counts instead of listing every count, but I am going to read the indictment.
Okay. That takes care of that.
So you're not going to do the thing that we did earlier? I mean, it doesn't matter to me.
Yeah, I think because with Sumter, it does take a long time. Do both sides want me to just do the summary as I did in
I don't have an opinion, Your Honor.
jury selection? And when we say summarize, I mean like in jury selection where it was basically putting multiple victims' names for each count.
Judge, we don't really have a position on that. We'll leave it to the court.
All right.
I think we did. I'll talk. Maybe it happens.
Well, I'll decide. I don't.
I just need to know how many deaths to bring, Your Honor.
How many what?
How many deaths to bring.
I think the state may have left out a couple of people that they didn't bring in on the indictment, Moon and maybe Adams.
Correct. We did not, Tyler Moon and Lynn Downs did not testify.
So I think we would have to, there was no evidence presented on those counts, so I think we would have to strike those counts.
That's not correct, Your Honor. We had a seating chart. We had a chart with Ms. Ryan where she said these children were present in the room. Had a separate seating chart that showed them present in the room. People testified they were present in the room, and then there was a video that showed the children present in the room.
Which counts are they?
Those, I have the indictment, Judge, in 1 second.
They are both, of course, only charged regarding mental pain.
So it's count 21 is Tyler Moon, and count 9 is Landon Adams.
Is Lynn, so they're both mental pain? Is that right, Ms. Daniels?
Yes, sir.
Is a jury permitted to wholly infer mental pain without any evidence?
Your Honor, there was evidence from multiple witnesses about how the room was behaving, everyone's fear in the room, and then there was also the video that showed the manifestations of the children in the room, so they could use that evidence to make that decision.
Judge, of course, we think those counts should be stricken because there was nothing specifically
you're asking for a directed verdict.
That, on those counts.
All right, 21 or 9. All right, we'll, does anybody have a case they want me to read on that?
No, you're right, just practicality. We routinely have counselors talk about how children behave and act, and in this case, there's a video of how they're behaving and acting. The jury can use to infer that.
All right. I will reserve ruling there and come back to it. All right. Any other issues with page 1?
Nothing to say now.
Mr. Hobbs?
No, Your Honor, and just for the record, that would be, those are all pattern charges, indictment, issue included not guilty, presumption of innocence.
Yes.
No objection.
All right, page 2. These are also all pattern. Danielle, is this mine modified, direct and circumstantial?
Yes, but all that you want, I just think out of parentheses.
Understand.
Yeah.
So, the direct and circumstantial, this is the pattern. There's a parenthetical, I think it's just confusing extra language. Do you remember what it is, Ms. Daniel?
The confusing extra language?
That I take out.
That's not off the top of my head,
All
but
right.
I know that the state does not object to it. I can pull it up.
All right. She'll pull it up and read it. The defense is asking for grave suspicion. I do get that charge.
And Judge, for the record, the state would object to grave suspicion just based on a litany of case law that says it's not error to not give it.
All right, overruled and given it.
Well, the paragraph of this off.
Someone's right in circumstantial. All right, we'll come back to that. Looking at page 3, we have the standard credibility of witnesses. Do y'all want their intelligence or not?
No, sir.
Ms. Daniel, do you?
We don't have any position on that.
All right.
Looking it up.
I'll just take it out. So coming back to page 2, direct and circumstantial, I generally give the short version, which is what this should be. It's in the, so it says circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. I put a period there. I think most jurors know what an inference is, rather than saying that is by consistency with such fact or elimination of other facts. I
I don't even know what that means, but
Well, that's why I take it out.
Yes.
So I put a
I'm
period.
fine with you taking that out, Judge. No
All right.
objection. There obviously has been movement to get rid of stuff like that as they're doing these patterns, so.
I think they've already redone that one, so they didn't.
Yes, I think so too.
That one they left. No disrespect to Judge McBurney.
Right.
All right. so we've got expert witnesses, going back on page 3.
Just for the record, Judge,
Yes, sir.
so I guess that means we're done with page 2.
Thank you.
So no objections to, on our part, to any of the 4 charges on page 2.
All right, thank you. All right, should be pattern charge on expert witnesses. I'm assuming no issue there.
No, sir.
All right, so then we've got, I think this was a state request, witness attacked. The only one that this could be applicable is the bias.
I would argue the character of the truthfulness shown by specificness as the conduct of the witness in question brought out by cross-examination.
But I think it's specifically related to the witness's character for untruthfulness.
Okay.
Yeah, I think it's the particular, like, truthful, untruthful, whether it's a reputation or some specific instance. I think you'll get what you want probably on the, with any other charges. You all want the bias?
Yes, sir, we do.
Ms. Daniel?
We wouldn't object to it,
All right.
and then I don't believe any felony convictions have been tendered for impeachment purposes.
All right, so from that one, I'll give the bias. All right, witness impeached, I generally give the, what's after the or. State has picked up on that at this point and made that request.
No objection.
All right, so for witness impeached, it'll be only the after the or. We have, we'll just go ahead and count prior statements on that's page 3, since it starts there. That's from the pattern. No issues there, I presume.
No objection.
All right, so page 3 is good. Is that right?
Yes, sir.
Page 4, we've got single witness. Any objection from the defense?
No objection, and just going forward, we'll withdraw our request on defendant's choice not to testify, obviously.
All right, now, you want it withdrawn in its entirety, or do you want me to, the defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness? You should evaluate such testimony as you would that of any other witness. I generally give that, I think I've always given that when the defendant testifies.
I would object to it, Judge.
You see, you do object?
I would not.
Okay.
Sorry, Judge.
That would be appropriate.
All right, so I'll just give this top part of that where it starts, however, I will not
Right.
give that charge.
Can we change the title then? Defense choice 2 testify?
Sure.
Right.
So this 132.15 statement of defendant, that's not an actual charge to give the jury, it's, I'll call it a bench note.
Yes, sir.
So that's not something I would read to the jury.
We can withdraw that, Judge. Make it easy.
So then we have, does your packet have limiting instructions? Does your packet have 134.00?
It has.
Okay, so we took out 134.00. There's no
Okay.
classic limiting instruction like other act evidence. But I do think I need to give 134.50 here, really conditional admissibility. They heard his statement or statements. They do have to make findings of voluntariness to be able to consider that statement.
Yes, sir.
All right, so I would give 134.50. Is there anything else on the bottom of y'all's page 4?
Statement of defendant, 132.16.
There's parentheses still in 134.15, not the top one, but in the bottom.
All right, Danielle pointing out a parenthetical in 134.50. In the middle, it is only admitted and you may only consider it if you find certain required, in the parenthetical, but disputed predicate facts. voluntariness, and I know we had a motion on it.
We did.
Do you want the parenthetical read?
Yes, sir.
Okay. Stand, I'm assuming y'all are fine, but if you're not, let me know.
Yes, sir. we're fine with that.
So page 4 then, we've got statement of defendant. All right, we good with page 4?
Yes, sir.
Yes, sir. No objection. I should say no objection to 132.16.
So I need to give 132.17 defining voluntariness. I don't think I would be given the parenthetical at the bottom of that charge.
We agree with that.
No objection.
And we would, I believe, withdraw 132.18. I don't think that applies here based on previous rulings by the court.
What's your position, Mr. Hobbs?
I think we would ask for it, Judge.
So the rub, and if you go back actually to that 132.15 on the previous page, that was really a bench note. Down at the bottom of that, if the court determines the defendant is or was not in custody, the court should give voluntariness charges only. So with Jackson, I did find that he was not in custody when he gave the statements.
Yes, sir, you did.
And again, jury has to determine voluntariness, but 132.18 does seem to be more appropriate if he was in custody at the time. What's your position there, Mr. Hobbs?
Well, I would agree you did find he was not in detention at the time, so we'll leave it to the court.
All right. So I'm going to take out 132.18, just it's not being applicable. I would, of course, give 132.19. So that make the constitutional rights, again, would not be applicable based on the ruling from Jackson Ditto.
Yes, sir.
So I'll take that out. Was y'all's page 5 in there?
No, sir. We have burden of proof as to rights, and conditions precedent considerations.
Right.
Um,
So burden of proof would come out
Yes, sir.
because of the constitutional rights coming out, so.
All right, so page 5, good?
132.50 on my page.
I have a slightly different packet.
It's only 3 lines of that on our page 5, the rest of it's on page 6.
All right, so let's count that as page 6. Page 5, good?
Yes, sir.
Yes, sir.
Yes, sir.
Page 6. So the state provided a version that retains the requirement that the statement be voluntary, but removes the issues with Miranda and those constitutional rights. Mr. Hobbs, do you have any issue with what's listed as the state's version of 132.50?
I would just object to any of it coming in. 132.5 doesn't fit based on you taking out 132.21 and 132.40, which I agree you should take those
statement, before you consider it as evidence, you must find it's voluntary, and it talks about all the things if it's not voluntary. But it never says, if you find it's voluntary, then it's evidence. So I think it's necessary to kind of close that loop.
Yeah,
I would just say that it does say to be voluntary, and it defines what voluntary is. The statement must be the product of a free will and not under any compulsion or necessity imposed by others, which I think is for every, covers that exact same, just doesn't highlight it.
What I'm saying, if you go back to page 4, 132.16, that's where it first starts talking about it. And the first statement is a statement that the defendant allegedly made is not for your consideration. Before you may consider this as evidence for any purpose, you must determine the defendant's statement was voluntary. And then there's lots of stuff about what voluntariness is and how if it's not voluntary, you can't consider it. But then you never go back and say, but if it is voluntary, then you consider it as evidence. And I think you need that charge to close that loop.
all right, over objection, I think it's appropriate. It's really just removing the parts of 132.50 that are inapplicable because we don't have to deal with the constitutional rights since it was not in custody. So I will give the state's version there. I was a little confused on 135.10.
We'll make it easy. We'll make it easy. We're withdrawing 135.10 and 135.11, Judge.
All right, thank you.
Of course.
So preserving your objection to the modification of 132.50 is page 6. Otherwise,
Definition of crimes on the code.
We have one more on ours.
definition of crime. What are y'all's thoughts there? So, and just go ahead and address intent too. You know, I've never tried a case where every charge was a criminal negligence charge. So I've never not given 141.10 intent, but I think it creates a problem for us with this being criminal negligence to give 141.10.
I would agree with the court in that I don't believe 140.10 fits the charges of this particular case. I would object to that.
Daniel, what's your
So
position?
you're just saying take out 14010 entirely rather than adding on?
No, 141.
Well, I think Mr. Hobbs is saying both would fall, but if I understood him correctly. But,
You did, Judge. Covered both. I don't think they're appropriate for this case.
And I think criminal negligence instructions, things of that nature would basically fulfill the role of those instructions in this very specific case.
All right, so are both sides then in agreement that 140.10 and 141.10 should be removed?
Yes, sir, and I think that would also be 14111.
Yes, sir.
All right. So all three of those then consent of both sides will be removed. States asked for 141.12. defense's position on 141.12.
What was the state's position?
They asked for
We're
it.
good.
I'm just trying to, I don't know if it fits.
I've stopped using that by and large unless there were some allegations of,
That's our issues. I don't think there have been any allegations that,
I think the natural and probable consequences of those acts kind of echoes a little bit our proximate clause.
And that would be our contention, Judge. These are, in this specific case with these specific charges, this presumption, which is an accurate explanation of the law, is relevant and will help the jury in making their assessments. They're having to measure against what the legal concept of a reasonable person is. And this, I don't think, has any negative reason. There's nothing negative to keeping it in, and I think it could provide clarity for the jury.
so we would object. We'd ask that it be taken out.
You could relate that to Colt, Colin.
All right, I think
It
it
would
just,
be confusing.
I'm gonna hold on to that one for a minute. So just consider that a reserve ruling. I don't know, did the state ask for 140.15 multiple ways? It could
Yes,
be?
sir.
And that's based on your criminal negligence, second degree, cruel, mental and physical?
Correct.
Those are the only charges you're really referencing?
I believe so.
Mr. Hobbs?
That's our objection.
All right, so I'll get that one. We have venue, you all take a look at the state's version and see if you have a problem with that. I mean, some of that is probably just based on my rulings in the past. I don't know why I'm telling a jury, in a prosecution, in any case in which it cannot be determined in what county the crime is committed, venue's proper can be proved in any county. That's just not an issue in this case.
I don't have an objection to the state's first objection.
All right. That is what I'm giving. All right. Murder in the second degree. It's from the pattern, except the state requested irrespective of malice, which I looked at the statute. It's in the statute. It's also in the indictment, despite the little bench note or whatever there.
No objection.
All right, so I'll give 21035 with the added element of irrespective of malice. Cruelty to children in the second degree, 22822. I added by consciously disregarding the substantial and unjustifiable risk that this act would harm the endanger the bodily safety of another, inasmuch as that is in the indictment.
And just, we don't feel that that's necessary to include there. I think the other statutory instructions are more narrowly tailored to the statute, and I think it'd be appropriate to keep cruelty, just that 1 through 4.
And we ask that you keep it in. It does track the indictment in the same way that 21035 does by adding that other number 2 subsection there for the state added element, irrespective of malice. We think it's the same thing for the next charge. We ask that you keep it in.
Yeah, I don't know that it was necessary to be in the indictment originally. And I had kind of a lengthy footnote in the demurrer order, but I think its inclusion that will be included with the cruelty to children second degree charge. And we have criminal negligence.
And Judge, we, provided that state's version, it does have a typo, and to be fair, I think it was our typo, not else, but it's for David's sake. The last word there says nearby, it should be thereby. And looking at it against the, pattern language, I think it'd be clearer and just as appropriate to just add or failure to act to the end of the pattern.
Mr. Hobbs? Originally, I thought, yeah, that makes sense when you're talking about negligence. But when you look at the indictment, it specifies an act. It doesn't, it doesn't leave in there or a failure to act. It is the act of providing the gun.
And we think it would be appropriate just to charge the pattern.
I don't want to run into a situation where, an appellate court says, well, that's an alternative way of proving it that wasn't in the indictment.
That's fine.
So I'm going to stick to the pattern on that. And we have involuntary manslaughter, unlawful act, should be, I think it's straight from the pattern. Anybody fine there?
Yes, there's no objection to the pattern.
No objection.
Reckless conduct.
So I would move reckless conduct. In your packet, Mary, you have moved, but to write under the involuntary manslaughter and unlawful act, to go ahead and define reckless conduct.
That's how we have it, and I think that would be the clear way to do it.
And that should be straight from the pattern. So any issue with the reckless conduct or page 8 in general?
No, sir.
No objection to the pattern.
All right, page 8 good?
Page 8 is good, subject to what we've already discussed.
All right, so then the defense has requested the involuntary manslaughter lawful act in an unlawful manner. And specifically, as a lesser for counts 5 and 7, which the state consents to, then also counts 1 and 3, which I have not ruled on yet. So, with the language of the charge, at least as for lessers in 5 and 7, does the state have an objection?
No objection to the language of the pattern.
All right. And then you have proximate call. What's that?
There's much for
Where? No. So coming back, Danielle pointed out there, parentheticals in the involuntary manslaughter lawful act. When the defendant acts or fails to act in a conscious disregard, for consistency's sake, would we just continue to say when a defendant acts?
I wouldn't, Your Honor, because I think we're stepping away from the indictment here. If you're talking about an awful act in an unlawful manner, it kind of leaves the unlawful manner up to them, and now the omissions and failure to acts come back into play.
What do you say, Mr. Howe? So lawfully, it's lawful that he have access to a gun, but he had it in an unlawful manner, or failing to take the gun away. Flesh that out just a little bit.
Well, I'm just saying, when you say lawful act, which they're saying having the gun and ammunition is lawful, in an unlawful manner, that's left undefined to the jury because it's not in an indictment. So unlawful manner could be omissions and failure acts. It opens that door for those to be possibilities also. The reason we took them out of the other was because it was limited by the actual charging document. But unlawful manner isn't in the charging document.
Mr. Hobbs? So, and really, it's applicable to, I guess, every count of the indictment. Is that fair?
Yes.
Yes, sir.
So where y'all have submitted your own request, and each side did, do y'all want to either forego the pattern, or?
Judge, we provided, but I think it looks like the way you've got it is the first part of our request immediately under that, which tracks very closely. We don't think that the criminal conduct accelerated the injury or death in a significant way applies here. And I believe our version lays that out. So I don't know that the state's request specifically drastically modifies the pattern. We just have the additional language, which I'll discuss with you if you want me to.
This way.
What is y'all's position, Mr. Collins?
Judge, we submitted a non-pattern request on proximate cause that shows up on our page 10. We'd be asking for that. Starts the overall causation
Yes.
required.
Okay.
That one.
The state had another one too, yeah.
Yes, sir. On ours, it's at the bottom of page 10. You'll get a kind of flesh out our thought there.
Yes, and both of y'all are citing Melanchon.
So Judge, ours, once you get past the language that tracks the pattern, we go on into talking about that previous requirements is fact intensive, demands mixed considerations of logic, common sense, justice, policy, precedent, which are questions of causation for the jury. That language is pulled directly from Rosenbaum versus State, which is 383 Georgia Appeals 417, which is a 2024 case. Rosenbaum in that language cites Melanchon, which is 319 Georgia 741, which is also a 2024 case. We felt like that language would be particularly instructive to the jury in this specific case. Those two cases that we're pulling from, and again, we pulled the language directly from Rosenbaum. So Rosenbaum is a murder in the second predicated on a cruelty in the second, of course. So I think the policy behind that tracks cleanly with this case here. That was a case where the defendant allowed his significant other to be alone with children who he knew the significant other was abusive towards, resulting in the death of the child. So I think sort of the mens rea there of knowing what can happen is very analogous to here. Citing Melanchon, it's also citing kind of a novel legal issue. Again, these are both very new cases, both from 2024. Melanchon was a felony murder case predicated on the possession with intent to distribute drugs. And so, again, in these cases, I think all three of these cases fall in this sort of intangible proximate cause consideration of the jury. So articulating for the jury what it is that they're considering, I think, could be particularly helpful. It's not harmful in that it tracks the exact language used by the appellate courts.
I don't remember Rosenbaum offhand. I think you may have those reversed. Melanchon was the abusive, leaving the child with someone who's been abusive in the past.
That's correct. Rosenbaum's a Clayton County case with the husband and wife. The wife was in law school and she was trying to The defense was that she was performing CPR in the child in injury state from the CPR.
I do have a copy of both of them. There's been a petition for writ on that case. I've got that before we like
And Judge, I was combining two cases, so that is accurate, and I do believe I stated correctly that Rosenbaum was considering Melancon. The same logic tracks in Eubank versus State, which is a 2023 case. That's the possession with intent, felony murder. That's 317 Georgia 563.
Which I think the defense side's in there.
And that's
Yeah, so in response to that argument, the language that the state is asking for determining whether the state has proven these requirements in any given case is fact intensive and demands mixed considerations of logic and common sense. Justice, policy, and precedent, which are questions of causation for the jury to decide. That language comes from Justice Pinson's opinion in Melancon. That language is what Justice Pinson is telling the readers he's using to analyze the causation issue. Not that the jury should be instructed to use that. To instruct the jury to use justice, policy, and precedent, number one, opens the door to telling the jury that they are allowed to set policy on a case like that, on a case like this. So, for example, if you have a jury who thinks the gun laws in Georgia aren't stringent enough, they can make their own policy to impose criminal liability on someone else. What's more instructive is going to be Justice Pinson's concurrence in the 2025 case, Adams v. State, which is 322 Georgia 155. Justice Pinson in his concurrence states, based on Melancon, what the jury charge for proximate cause should be. And in that paragraph, he does not mention justice, policy, precedent, anything like that. Now in Melancon, after he gives that analysis, he then goes forward to analyze those different aspects when considering what happened in Melancon. So for example, he does look at policy by stating that you can be a mandated reporter, which is a very narrow class of individuals, and fail to report something that then leads to a child's death and only be subject to liability for a misdemeanor, as opposed to not being in this protected class of persons who is required to report certain things, and now you could be charged with murder in the second. And the examples he uses are you could be a social worker, a defects worker, someone along those lines, a parent, a babysitter who doesn't report something, and based on that be subject to being prosecuted for murder in the second, as opposed to the policy consideration that's been granted on mandated reporters. And so he does analyze it in those terms, but he's not authorizing that it be used as a jury charge. The jury, when determining guilt or not guilt, should look at the evidence, not other considerations of their version of justice, policy, and precedent. That would suggest we would have to argue case law to the jury in our closing about Melancon and Rosenbaum and Adams and Eubanks and just down the litany of these cases.
From the state's request, is that sentence, the one you've just been discussing, is that the only offending sentence in their charge, or?
It's the most offensive. I'll say that.
I think the rest is pretty much the pattern.
I think the rest is pretty much the pattern.
Is there anything in your?
I will say that, and the state's already agreed, the language about accelerating the death is we would agree is not necessary.
Is there anything in your request that you believe needs to be included somewhere? I mean, I don't, well, I'll just say that. Is there anything in your request that you're like, this isn't covered elsewhere, we need to include this? cause requirement specifies requisite foreseeability or likelihood of death happening in the way it did during the defendant's conduct, is that the?
That part, yes. And requiring the death in a way that was reasonably foreseeable, but that's kind of covered by probable or natural consequence.
Judge, I don't know that that's necessarily an accurate statement of the law. I think the way the pattern lays it out makes it clear what the jury is considering. I think once you introduce, so we're already dealing with proximate cause, which they're having to wrap their head around, and then we're bringing in cause and fact and legal cause and defining those and breaking them down. I think it's just getting confusing and kind of derivative. I think it's getting away from what it is that the jury's actually having to consider.
I will kind of take a closer look at the pattern and what each of these requested there. So, I realize y'all don't. So if we didn't discuss it, it's otherwise fine.
Yes, sir.
Yes, sir.
We have state's request. What are we talking about now?
That's what we're- yeah. Right.
This is a new one, state's request here. Recordings of interviews. Was there more than, we fast forwarded during, investigator gets up, leaves the room, or?
We edited it. Remember, we had to edit it on the fly, because of
There was
statements
something,
they made.
yeah.
So we had to edit portions out.
And Judge, this is a issue that the state's come across with juries, I'd say repeatedly and increasingly, and I would assume honestly the defense has as well, that the more and more we have things recorded, and the more we have the capabilities and navigating, redacting things from recordings played for the jury, it's the state's opinion that it's always going to be helpful to acknowledge it instead of sweeping it under the rug. If we can tell the jury that, hey, everyone's on the same page here, things weren't played, but don't hold it against either side.
And I think in this case, it cuts with both, Your Honor. The state fast forwarded it on our motion to get through inactivity, but the defense objected and parts were edited. So they could hold it either one against either. So I think it's just better and safer to do it.
Just, we don't have a big problem with this.
Yeah, I don't see any harm in giving it, so I'll go ahead and give that request to charge coming in on redacted videos. All right, I realize we don't have a verdict form yet. And generally what I do in the verdict, generally I will also hold up the verdict form and kind of explain it to them.
And Judge, obviously this is going to be, regardless of the court's rulings, kind of a lengthy verdict form. Are you
Yes.
wanting the state to prepare that, or is your office preparing? Who do you want to?
Y'all have more staff than I do.
All right, happy to. Just wanted to make sure we weren't.
And we usually just have a blank. We, the jury, find the defendant blank, and I'll say fill in not guilty or guilty in accordance with your verdict there, so that you guys are aware. Unanimous verdict. Court has no interest. And usually do cut down sympathy. And y'all tell me, because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status, for or against, surely we don't need all those.
I wouldn't think so, Your Honor.
No, sir.
me what you want left in. Or do you want me to just put a period after, before it starts that?
Period after prejudice, man.
Yeah, I mean, you are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. I can put a period there if y'all.
I think that'd be
Or
fine.
you can just put in the citing state she's not being influenced by sympathy or prejudice. Period.
Can put it there. Shots.
No, I agree with Mr. Barry. I think it's fine to put it, the period after sympathy or prejudice, and then get rid of because of race. Leave all that out.
Okay. Sentencing standard, deliberations is standard. Anybody have any issues with any other portion?
No, sir.
No, sir.
All right, I'll have to take a lengthy recess to kind of sit through the lessers and some of the others. Is there anything else we need to address?
I think if we have time before the jury, it might be time efficient to address what goes back with the jury, that if,
Yeah.
I'll talk to defense counsel about that while you're, on recess.
Y'all may be able to agree on some stuff.
One
We'll
will
talk,
help.
see if we can agree on a
Okay.
lot of this.
All right, paying attention. So.
Well,
I'm not sure what we can agree on, but that's
Brian and I definitely agree on it.
I'll talk to Andy.
okay, we'll take a recess so I can work on that, I know that's important. I would give the pattern lesser charge, lesser offense charge, 16011.
Yes, sir.
Straight from the pattern. All right. We'll do the heavy lift.
That's the vibe I got.
Yeah, that's fine. He's gonna do it, so.
I just agree too.
Brian said, I think we feel a lot more should do that than at least than Mary feels. If y'all want to tell us what you don't, I think
Oh, exhibits.
it's a to y'all.
Oh.
You do that now, so.
Yeah. We can do that. Why?
Yeah, if y'all want to kind of go through it, I think these facts records, I'm pretty sure we would agree to, but the vast majority of the other stuff, I think our position would be this. So if y'all want to kind of
We have
parse
some
through what you
objections
do.
we're gonna make about text messages and things like that.
Okay.
But I know what the case law says.
Right.
It's more of a,
Pretty clear, yeah.
we're trying to anticipate
Right.
a change at some point in the law, but
Sure.
we will acknowledge the case law is where it
Fair.
against us on that.
We prepared the PowerPoint without headings and writing, so all the
Okay.
content of the PowerPoint without any commentary. So it should just be screenshots.
Check it out.
That's fine. Figure it out.
It's gonna be gone for a minute.
Yeah.
Cool.
I guess as long as the courtroom's open with security, I guess we're fine.
Nothing's perfect. People who think AI is gonna do it, they are so.
Oh, no, I use it
Yeah, I'm
for,
gonna key in
you know,
on
body
that.
cams and stuff like that, just to get a general idea, but it's messed up all over the
Oh,
place.
yeah. I mean, there's certain things that we use in our, you know,
I'm
but
sure.
it's just not.
It's a good guide, but it's not close to being accurate that I could use it in court. Yeah, no way.
I'm not worried about my job at all. I started talking about that, 20, 30 years ago, talking about.
No, it's not close to being accurate.
I've tried utilizing stuff, you know, not it's easier for me just to do it.
Oh, yeah. Yeah.
Human interaction is so much more. Well,
No, you can't.
when you have a competent human.
It does a terrible job when people talk over each other, which is most interactions in our job.
It happens
Yeah.
all the time. See, we're doing it right now. I did that on purpose, actually.
You are correct. No, it cannot sort people out.
Because that's
We'll just
human
get a
nature.
paragraph.
It's human nature to talk, you know, over someone. Yeah, that was intentional. I'm not that rude. I like to prove points.
Good job.
Yeah, I know.
Me too.
It's like, yeah.
I can just sit back and watch.
What the hell am I gonna say for a couple
Right,
hours?
right. The rest of my day is easy.
Yeah.
Perfect.
Well, that's what, like, leading into it, like, Brad was getting ready for Prosecutors, and you're closing, it's like, I guess I'm doing the charge, but like, it doesn't
I
seem
can
like
see
anyone
how
else
this is
does.
gonna go.
Yeah. You know that this is the last place to start coverage.
Yeah, it's fine. Great. Well, that's
I don't
good.
think they'll get it till, and we're trying to do the math, like 3:30 the earliest.
I think closer to 4 by the time, because it's gonna be a long
He's like,
charge.
Just for guidance.
he's like, interested parties wanna know what we're looking at.
Roughly time slots.
I know, I kinda wish he had popped in during Friday as far as like,
Yeah, 'cause it's
hypothetically, if he wants to
12:30
late
to-
or.
Right. Or it's open like child care plans.
Yeah.
Or stuff like that, because
Right.
sometimes people can't.
Right.
We'll see.
Yeah, and Britain's usually pretty deferential to the jury.
Yeah.
Like staying late for
Yeah.
some of that kind of stuff.
Do y'all think he'll charge them tomorrow?
No, I don't think we go, because if we start,
If we start on time.
I was gonna say, yeah, I'm not getting we're not behind as of now. So if we started at 12:30, even if they both took an hour and a half, which it'll.
Then you'll give them a break,
Yeah,
probably in between, maybe not, but definitely after.
yeah,
You think he's gonna charge them today?
I think so. I don't know why I wouldn't.
And then go ahead to deliberations today?
We'll leave that to them.
Yeah. So I always like impart my own, like, if I was on a jury, like, I'm just saying, I just wanna get it done today.
It's hard.
So like, I don't wanna come back tomorrow and knock it out, and I'm like.
I know, it's hard to predict, yeah.
It's 3 weeks.
Yeah,
There might be a lot of stuff to go through.
right,
And
yeah, who knows, yeah. Anytime you guys are on. They're very kind but not very moving. I mean, a couple of them. Yeah, like. Yeah, no.
We got a little break.
I can't believe we still have all that's hard. I mean, I feel like we get to a point at like 50% of the time, yeah, I know. It's like kind of normal. Yeah.
5 days, hey, you got some.
No one ever been late. Like, what is this Fall County? Like,
No.
it's not very much, that's for sure.
You know, we were joking like the, I think the case up here for a while. It's like an hour and a half each way. So
That's
trying to
a-
drive it.
Well, driving from where y'all are over to this side sucks. I take one. Where are you guys driving from?
I live in Woodstock. He's in Marietta,
So you like have to take two
Yeah.
right?
but he's 83, so I pick him up every day at the office.
There are reasons that Brian drive.
Marietta, about the square. So it's on the way.
I tried
It's
to
only
put
it's a
it
little
in. I
detail.
tried.
No, no.
But I've had to
Yeah,
switch
good.
cars with my wife, because I have like a car. where She doesn't actually, he doesn't like.
How she likes that.
She's okay. She's fine. But it's easy. I want to take it out of him.
So like it's listed.
He's gonna be like, finish up.
Brian's precious.
You're old as shit. Go ahead. You can do this. It's like not your first trial. And you're like,
Sorry. The camera is recording audio, or,
Oh, good.
so
I thought they were not supposed to
We're not
do
supposed
that.
to, when he's not on the bench.
that's why I'm here. Are they over there?
Television.
Oh, they're not, it's not, y'all.
Who's recording?
It's of the seal, but you're
It's
still
just
picking up
Brian and I
audio.
shooting the shit.
Hostage.
No, that's not you. That's the younger guy out there.
Good, nice.
You tried to film the video? Yes. This is at my, gas station. Well, I'll wait for the guy.
Sir, 1 minute ago, text from Ashley Butler. Hotline. Is your theory is right? I'm guessing you will be on the injections. Right.
No. No, absolutely.
Mm-hmm.
All right, we're all present. To be honest, I'm not sure the door is closed on some further argument or clarification. These are the dangerous waters. That's why I wanted to get to this on Friday, but we didn't. So let me start with the directed verdict for counts 9 and 21. I do think that's the directed verdict required. I'm going to cite Jones v. State, 304 Georgia 594, 304 Georgia 594. So grading the directed verdict on counts 9 and 21. As those